Hello, and welcome to the Second Call Defense podcast. I'm Dean Reek, and I'm joined by Sean Maloney, firearms attorney and co-founder of Second Call Defense. Hi, Sean.
Hi, Dean. It's great to be with you again today.
Sean, I saw a story recently about a guy involved in a road rage incident. He said this other guy cut him off, and they both ended up in a parking lot off the road, and they got into this argument. One guy threatened the other, and then the first guy went to his car, got a gun, and shot the other guy who was just sitting there in his truck. And he claimed self-defense. Now, immediately I thought of you because, there's so much confusion out there about self-defense, and especially when you can use lethal force. This case didn't sound very good, and I thought, well, these two guys really need to talk to you. And so I thought, well, let's just talk to Sean, talk about lethal force, and when you can actually use it. So why don't we just start out by talking about what lethal force actually is? Is that just a gun or a knife, or what's the legal definition of lethal force?
Dean, it's strange that you saw that article because I've recently had two cases that I've just accepted that we're dealing with similar cases like that, almost exactly, where people have used lethal force when really they shouldn't have used lethal force, and maybe it's because they didn't listen to what we're about to tell them here today. Essentially, lethal force is lethal or deadly force. It's a force that's likely or intended to cause death or serious bodily injury or harm. Now, no, you don't necessarily have to die, or someone doesn't have to die when you use lethal force, but it can be anything from a firearm, a knife, a baseball bat, and a frozen bag of squirrels, like you and I have talked about in the past. Anything that you can use as a weapon, so to speak, that will cause death or serious bodily injury or harm. That could be your car. Think about it. It could be almost everything. If you look in your office, what could you use? It could be a pen, being stabbed with a pen, hit with a laptop computer in the side of the head. So it can be any number of things, just not a firearm like we think about.
I think we need to back up to the frozen bag of squirrels. Can you explain that?
Yeah, I always use that for an example. It's an actual court case out of San Francisco, California, where two gentlemen were having a dispute. And someone just put a property line fence up, and it seems like there's been more people killed or arguing over property lines than you can ever imagine. I represent several of them, actually. And in this case in San Francisco, two gentlemen were arguing. The one gentleman went back inside and was a hunter and had a frozen bag of squirrels in his freezer. So he grabbed that frozen bag of squirrels, came back out in the driveway, swung it, and bludgeoned his neighbor to death with a frozen bag of squirrels. And I always noted that it was interesting because it happened to be in Nancy Pelosi's congressional district and senatorial district. She never banned frozen bag of squirrels, so they don't ban everything. And that was kind of proof of that. So that's why I always kind of humorously bring up frozen bag of squirrels, but it helps to point out that anything that can cause serious bodily injury or death can be used in self-defense.
So there is such a thing as an assault squirrel.
Yes, there is.
Well, we definitely need to ban those. That's just not right. So, all right, so that's lethal force, basically anything that could potentially cause death or serious bodily harm. So when can you use lethal force? What's the standard? I've always heard, ability, opportunity, jeopardy. I'm not sure that was always clear to me. But do you have a definition of when you can legally use lethal force?
When you're talking about using lethal force and when can you legally and reasonably use self-defense or lethal force in self-defense, it's always good to kind of finally have a bright line rule. And the first thing that we want to state is if you are in fear of death or serious bodily injury or harm, right now, there's no way to avoid it in a duty to retreat state. So essentially, if you're in fear of death or serious bodily injury or harm, that's the standard. Why did you fire and shoot this gentleman 3 times in the chest and cause a breathing problem so bad that he died? Well, I was in fear of death or serious bodily injury or harm. Now, is it good enough for you or I to go to a judge, a jury, or a police officer at the scene and say, well, I was in fear of death or serious bodily injury or harm? Well, sure, it's subjective. What do I think? Not what does anybody else think? But then how do I go about proving that to the judge, the jury, or whoever the trier of fact is? Well, and you mentioned them. I always think about ability, opportunity, and jeopardy, or administration of justice is kind of what I put in my head. So the ability. I have the ability. I'm right here, right in front of you, and I have a knife in my hand or a gun in my hand. And then the opportunity is I'm 5 feet away. So all I have to do is swing the bat, push the knife, or press the trigger, and the ability and the opportunity to do that is done. And then jeopardy, simply, am I in fear of death? Have you put me in jeopardy or fear of death or serious bodily injury or harm? So administration of justice, ability, opportunity, and jeopardy. So I have the ability, I'm right here. I have the opportunity, I'm right in front of you, and I have the right weapon in my hand for the proximity, and then I put the other person in jeopardy, or I am in jeopardy.
Now you talk about grave bodily injury that you don't have to actually, die before you use lethal force. Obviously, what would constitute grave bodily injury?
Uh, a broken arm with a baseball bat, a head injury of any kind, uh, anything where there's serious injury more than just a slap in the face, so to speak. And you never know how far anything is going to go. Certainly with a baseball bat, I don't have to know that a baseball bat is going to kill me, but certainly crashing and smashing my forearm is enough. That's serious bodily injury. So it's grave or serious. It's something more than what a Band-Aid is going to take care of, so to speak.
So I've seen statistics, Sean, because people are always talking about assault weapons, rifles being used to kill people. But there are a lot more people who are killed, according to the statistics, just by hands, fists, and feet. Just beating somebody up, kicking them. Somebody can just swing their fist at you and cause you grave bodily harm.
You're absolutely correct. Statistically speaking, more people are killed in the United States with hands and feet every year than with firearms. Uh, and it's kind of common if you read case law and what's happening. There's people that end up getting charged with manslaughter, certainly usually not aggravated murder, but you're starting a fight. Well, the one person starts a fight, he finishes the fight, and the other person dies 2 or 3 days later in the hospital or dies right then and there. So certainly that's lethal force, and something attacking you with hands and feet is putting somebody in fear of death or serious bodily injury or harm. And we have to remember that it just doesn't take someone with a baseball bat, a knife, or a firearm for you to have a reasonable person to use lethal force in self-defense.
Now you're talking about reasonable person. And I want to talk about that a little bit because it's not enough that you just say that you think that someone was going to harm you or, cause death, great bodily injury. There's what's called a reasonable man standard. And that, if you go to trial, that's what's going to determine whether you were right or wrong. Can you talk about that? What is a reasonable man or a reasonable person standard?
Sure, and a reasonable person is created out of the mores, the thoughts, and the feelings and the customs of the portion of society you happen to be in. Cleveland, Ohio, for example, or Dublin, Ohio, or Cincinnati, or Newport, Kentucky, where you live. A group of people, essentially, you're looking at the reasonable person. What would a person faced with the similar facts and circumstances have done under those circumstances? And if a reasonable person from that group of people would have done basically the same thing, facing the same facts and circumstances, then you reasonably use self-defense, or you reasonably acted.
So in a trial, for example, how does that play out? The reasonable, I mean, because the rule is that you're judged by your peers, right? You're not, if you commit a crime in Ohio, you're not going to be in a trial out in California. You're going to be ideally where you live or where the incident took place, right? So it has to do with the reasonable standard where you live. How does that play out in a court case?
Well, you have to think about that, and I'm glad you brought that up, Dean, because when you're talking about the reasonable person, I think we can all agree that the reasonable person is different from Cincinnati, Ohio, or Dublin, Ohio, than downtown Chicago or San Francisco or New York City, someplace else where you're highly anti-gun and people just don't think like we do, Massachusetts. So when you move from jurisdiction to jurisdiction, the reasonable person standard is going to change somewhat. sometimes the reasonable person standard changes greatly. Other times there's just some small modifications of it. But the way to defend yourself in those situations is you have to have local counsel or a local attorney representing you in that jurisdiction that could portray you as a reasonable person, or you acted as a reasonable person in Quincy, Massachusetts would have acted, or San Francisco, California would have acted. So they're going to change from place to place. Even from Cincinnati to Cleveland, Ohio, the reasonable person standard is going to change somewhat. So you have to make sure that you have local counsel there that can create you as a defendant, the reasonable person under the same circumstances or similar circumstances that any other person would have acted.
Yeah, I've seen videos where, somebody is pulled over and a police officer will ask them, do you have a firearm on you today, sir? Or something like that. I saw one video where the person said no, and the officer said, why not? That they sort of expected, why aren't you carrying a firearm? Now, in another jurisdiction, the officer could be very suspicious. Why are you carrying a firearm? Why did you think you needed that today? So the thinking can be very different from place to place.
Well, exactly. And the plain language, the jury is going to consider what a reasonable person under the same or similar circumstances, knowing what that person knew at the time, have acted the same way. And that's the perfect example. I have a kind of a penchant for getting pulled over from place to place. I left a concert in Cincinnati, Ohio, and kind of got lost in the wrong part of Cincinnati. And I was pulled over by the police. I'm trying to think, what in the world did I do now? And he realized that I'm in a red F-150 pickup truck, and that really is not in this part of the neighborhood. And I got pulled over, and they said, "What are you doing here?" And I said, "I'm lost." And they said, "Obviously, you need to follow us and get out of here." So society changes and parts of town changes, and the way someone's going to treat somebody else and react to any situation is going to be different. And that's the way to look at it too. How is a reasonable person going to react to that situation? Well, obviously, if you've never been confronted with anything like this before, you're going to react differently than somebody that has these same things happen to them day in and day out. So that's how you have to craft a reasonable person.
Well, that's an interesting point, because I remember taking a self-defense class once, and the instructor said something that surprised me. They said, most men have never actually been in a physical confrontation. They've never had anyone lay hands on them. They've never had somebody punch them in the nose. They've never been in a fight. And that can affect the way that you react. This particular instructor not only dealt with firearms, but was into jujitsu and everything else. So they were used to, hands-on confrontation. The way that person reacted would be a lot different than somebody else who had never been in a fight. How do you deal with something like that, where somebody is so shocked that someone is tackling them to the ground or something, that maybe they overreact? How do you deal with something like that in advance?
That's another good question, because I teach concealed carry. In fact, I'm teaching a class tomorrow as a sub-instructor. I haven't taught in years, so this is going to be kind of exciting. I enjoy teaching that. But that's something I always say. I said, raise your hand at the beginning of class if you've ever been in a fist fight, a playground brawl, or anything. And you'd be surprised. Like you said, hardly anybody raises their hand. And I said, well, you guys need to go take a self-defense class. You need to get thrown around a little bit. You need to get beat up a little bit. And you need to get that adrenaline pumping and understand what's going on. Because if you've never been in a fight, if you've never been in a wrestling match or something like that, you're going to have no idea how you're going to respond. And that's where the reasonable person comes in. But whether you were in fear of death or serious bodily injury or harm, that's subjective. What did you feel at that time? What can you say? Not what anybody else thinks sitting on the couch, but subjectively, what did you feel and why did you feel it? Well, I felt that way because the person had the ability to harm me, had the opportunity with the tools in their hand right in front of me, and put me in fear of death or serious bodily injury or harm. So really, it all comes back to that same standard. I was in fear for death, or fear of death or serious bodily injury or harm, and then I got to prove it by the person had the ability, the opportunity to harm me, and put me in jeopardy or fear for my life. So that was a perfect question, Dean, because it brings everything full circle.
I'm wondering, do they even do things like, wrestling in schools anymore, where it's like mandatory, not if you're on a team? Because when I was growing up, everyone took wrestling. It didn't matter whether you were going to be on a team or not. We played dodgeball, which I think they've outlawed now, where you're whacking other people in the face with a dodgeball. It was pretty routine, and I was in what I would consider a normal number of fights when I was a kid. But I don't know if any of that happens anymore. Do kids take those kind of classes where they're hands-on with people?
Dean, another good point to make. I'm not sure if they do. We all had gym class, and we all had to wrestle in gym class, and you had a week or a month of wrestling or whatever it was, and we also had the trampoline. Of course, they removed the trampoline, a few broken arms and legs later, so now people don't have the opportunity to do that. And we played dodgeball also. And I'm not sure they do that anymore in today's woke society. And protecting our kids so much, I doubt probably anybody is involved with semi-rough sports anymore or physical activity to get acclimated to what's it like to have to defend yourself, or what's it like to get the adrenaline going.
So, Sean, what about the idea of duty to retreat? Because every time a state deals with, castle doctrine, stand your ground, or any of this sort of stuff, or passes concealed carry law, this idea of duty to retreat comes up. How does that factor into it? I know here in Ohio, we basically got rid of the duty to retreat, but it may still exist in some other states. How does that factor into self-defense?
It factors into self-defense in a big way. In fact, Buckeye Farms Association was instrumental in removing the duty to retreat in Ohio, which really needed to be done and needs to be done everywhere. But not every state has stand your ground laws or no duty to retreat. So let's look at it this way. Let's go back to I'm in fear of death or serious bodily injury or harm. Nothing happens. The duty to retreat, stand your ground, the use of lethal force doesn't happen until after I determine subjectively that I'm in fear of death or serious bodily injury or harm. Now, in the state of Ohio, or a state that has no duty to retreat, as soon as I make that determination, he has the ability, the opportunity, and put me in jeopardy, and I can use lethal force right now. So in the state of Ohio or any no duty to retreat states, as soon as I make the determination that I'm in fear of death or serious bodily injury or harm, I can use lethal force in self-defense. Now, if I am in the duty to retreat state, I make that same determination. I'm in fear of death or serious bodily injury or harm right now. I can't act yet. The next consideration is there a way that I can possibly safely retreat and remove myself from the situation? But if the only way I can save myself is by using lethal force, then I can then use lethal force. But having that second pause to determine, after you've already determined that you're in fear of death or serious bodily injury or harm, now I have that second question to answer: can I safely retreat? So in the duty to retreat states, they have that part too. They have to also make the determination that no, there's nowhere I can go. So, and those are the key differences. As soon as I make the determination in a non-duty to retreat state or stand your ground state that I'm in fear of death or serious bodily injury or harm, I'm free to act. In a duty retreat state, I make that same determination that I'm in fear of death or serious bodily injury or harm. Now I go to part two: can I safely retreat? And then if the answer is no, then I can use lethal force. If the answer is yes, then I guess I have to run away.
Yeah, that's never made any sense to me, because it seems like it's just illogical. Either you're facing death or you're not. And if you are, why should there be any other consideration? We got rid of it here in Ohio because it just doesn't make sense. It just seems like a way to trip people up when they finally get into a court case, that they have to prove something that really they didn't need to prove in the moment.
From the beginning, I could never think of a situation or a hypothetical where once I was determined I was in fear of death, serious bodily injury or harm immediately, well, then I can retreat. Well, I can't square those two things. I'm going to be killed right now, and I can retreat. That doesn't make any sense to me. It never did. So that was just a bad piece of law, that common law that came from somewhere hundreds of years ago, that finally we got straightened out.
Well, Sean, thanks for going over all that with us. I think that does clear it up quite a bit, and I hope that those two guys who got pulled over, I hope they work out their differences, and maybe they'll listen to this podcast and get straight on the law. So that's it for now. If you're not a member of Second Call Defense, go to secondcalldefense.org and sign up for the complete self-defense legal protection that they offer. We'll see you next time on the Second Call Defense podcast. Be safe.